Hi guys, let's talk about default in relation to your divorce. Let's say you cannot find the other side, or they're not cooperating, or they're saying, you do all the work, I'll sign whatever. So you have a situation where you want to get divorced and the other side is not willing to put the work into it. Therefore, what you do is then you file petition, summons, and whatever local form. In San Francisco, it's ADR form 11.17. File that with the court and then serve it to the other side. The way you can serve is either in person by hiring someone other than you over 18, professional process server, or if the other side will say, I will sign everything, then it would be an acknowledgement of receipt. So in personal service scenario, they don't need to sign anything. They just get served in person, that's it. In the mail service, they would need to acknowledge that they received the petition package, the 2 to 3 forms. And that's the form FL 117. So now you have a proper filing for divorce, service of the divorce paperwork, and then you will see, aside from automatic restraining orders, which is not the topic of the day, but you will see there's 30 days for the other side to respond, which they're not going to do. So then after 30 days, it creates a default scenario where they are defaulting on responding to your divorce petition package. Third version, we didn't talk about if the other side disappeared completely. It's service by publication, but the video is purely about the default. There is another video about how to serve those 3 ways more exactly, and service by publication deserves a whole another video. So let's say we have a service. Then you prepare a judgment package. The way you prepare the judgment package is going to be a mirror of what the petition package said. For example, you don't say to be determined on the petition package if you know the other side is going to default and you have to do all the work. So it has to be literally a mirror of the judgment package. So for example, what mirror means is that the FL 100 on number 9 and number 10, number 9 is separate property and number 10 is community property, will include an attachment which is simplified financial form. It could be form FL 160 or your way of simplifying it, where you state who is getting what. For example, all accounts ending with XYZ in my name and credit cards and ending with XYZ in my name going to be on my side awarded to me, and the same thing for the other side, whatever their account numbers are in their side. So there was a case, and again, this procedure and the scope of that is defined in Civil Code of Procedure 580. And it says that there was a case in 1990, Lippel case, Lippel, California Court of Appeal, and then it was eventually Supreme Court's decision where the court said it cannot exceed what was in the complaint. California Supreme Court disapproved exceptions. And that was an exception, for example, if the side who filed asked for sanctions and they asked for sanction here and not here, and the judge said yes, but Supreme Court said no. So we cannot make exception to the CCP 580 rule, meaning it has to match. Before that court, there was another case in 1988, Wells, WELLS, Court of Appeal, where the property division sheet does not require values or proposals complete. So the complaint was that the petition didn't include values and proposals, but the final judgment did. This case, remember, was 2 years before the Supreme Court. So nobody has decided about the Wells case. To be safe, don't do that. Include values, include proposed division, because this case is a little wacky given that there was a higher court case saying Miro, no exceptions, 580, done. Finally, when you fill out the petition, also the spousal support form, make sure if you are asking for spousal support that amounts are clear. But you cannot have a clear amount if you don't know the other person's income and expense declaration and how much they make. So if you want to terminate, then make sure to really go through the form and make sure that it matches. Otherwise, if you made a mistake, you filed before you served the other side, you can amend it and then serve. But if you made a mistake and served, then you would need a court's approval to amend your initial petition, which would require a hearing. And if the other side is not cooperating, then it's a problem. So now we have two scenarios. Pure default, the other side is completely not doing their due diligence and not cooperating. Then what you need to do is you file, you serve, you prepare your preliminary declaration of disclosures, and then you serve everything at once as a judgment package to the other side. You could even serve the initial petition. You could serve everything, but you have to wait 30 days. So you serve the first part, wait 30 days, and then serve preliminary declaration of disclosures and the judgment package together, right? So, and in order to know which forms to fill out, check out FL 182, which is judgment checklist. And the first thing you will see, judgment without, pure default without an agreement, the other side didn't file for response. And the second one is default with an agreement. An agreement means the other side will sign the agreement about what you decided. So that way you don't need to mirror everything because you will have an agreement that specifies. So if you wrote in the petition TBD, that's fine. You just have an agreement and say, this is mine, this is yours. And then the other side has to notarize their signature. In California, that's what they have to do. And then you check out the judgment checklist and make sure it's all correct, like what you need to file, the proof of service that you served them the petition, the proof of service that you served them preliminary declaration of disclosures, the notice of entry of judgment, FL 165, FL 170, FL 180, FL 190. I mean, it's a whole thing. Finally, the beauty of the word default for the other side. They don't have to do preliminary declaration disclosure. Officially, they don't. But you do need to know in the judgment, in the agreement, what they get. So you would need to have some basic information, what assets to assign to them. But that's sort of for lazy other side to figure out how much they want to put in their column as assigned to them. Anyway, I hope that was helpful. And if you like the video, click like, subscribe, and I'll see you soon. Bye.